Hey everybody, welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel, doing this like we do each and every Thursday night with our live stream, the live Q&A, where we talk about all things debt related. And we don't just dabble in debt. We deal with the ugly stuff, bankruptcy, garnishment, debt collection lawsuits, all those types of things. So my name again is John Skiba. I am an attorney in the state of Arizona. I handle consumer bankruptcy cases like Chapter 7s, Chapter 13s. I also help people who are being sued by debt collectors. Particularly, we deal with a lot of junk debt buyer lawsuits, Midland Funding, LVNV, Resurgent, Portfolio Recovery, all those other junk debt buyers that are out there. So if this is your first time here to my YouTube channel, I have a ton of content that helps to provide information for people. My whole goal is to provide some hope and some resources and maybe point you in the right direction as far as how you can help deal with some of these serious debt issues that I'm sure are keeping you up at night and causing a lot of stress. My disclaimer, I am a licensed attorney in the state of Arizona. I'm not licensed anywhere else. Things do vary dramatically from state to state. And so you shouldn't take any of this as legal advice because it's not. It's just me talking away on YouTube. So take it for what it is worth. I want to mention our great sponsor of these live streams each and every week, SoloSuit. SoloSuit offers technology and different products to help with answering debt collection lawsuits, with debt settlement, and a lot of other really cool products, including motions to compel arbitration. I put a link in the chat on Facebook and on YouTube. Go ahead and check that out. That's a great way to get some help that you need and a great way to also support this channel. So the way that we do this each and every week is if you have a question, put the question in the chat section on YouTube or on the comment on Facebook. I will put it up on the screen and I'll do my best to provide you with some general information about this. Again, if you need specific legal advice, I highly, highly, highly recommend you talk to an attorney in your state. If you're in the state of Arizona, you can actually talk to me. I offer free consultations. And you can actually book that directly. I'll put that link in the comments section as well. You can click on that, set up an appointment. You'll talk to me directly. I do all the consultations here at my law firm and can give you some general advice as far as which way to go and even take on your case as far as representation if you're in the state of Arizona. So I was looking through the comments online and there were some good questions that I thought might be helpful for everyone. This is a question I get frequently related to bankruptcy. Can you file for Chapter 7 as a married couple or just as an individual? And often I get the inverse of that question. Can you file as an individual or do you have to file as a married couple if you're married? Now, it's a good question. And it does have some layers of complexity that you might not be thinking about, particularly if you're in a state like Arizona. Arizona is one of 9 states in these great United States that is a community property state. And what that means in big kind of high level terms, a community property state is a state where assets or debts that you get while you're married are generally considered joint. So if I go out and buy a new car on the way home from work and I don't tell my wife and just my name's on the title, she's still part owner of that vehicle under community property laws because it's an asset that we incurred while we were married. The flip side of it is also true. She's likely liable for 50% of that vehicle because of these community property laws. So, but in relation to bankruptcy, I can tell you that I often, if couples, particularly if they've been married for quite a while, if someone comes to me and they're like, hey, we've been married for 15 years. We have all these credit cards. Some are in my name, some are in her name. What should we do? I generally recommend that you file together. The reason being, it's a lot cleaner. There's no loose ends because it could be that if a credit card is in your spouse's name and you file for bankruptcy, they're not going to come after you, but they could come after your spouse. And so that could cause you some problems down the road. Also, when you file a bankruptcy for a Chapter 7 in particular, you have to qualify for the bankruptcy. They do what's called the means test. So we look at income for the household, as well as the number of people in your household. And now, even if your spouse is not filing, we have to include their income to determine whether you qualify. So basically, you have to disclose all of the community property assets. You have to disclose income, household expenses, all those kind of things. And so I always say it ends up being a little cleaner. That being said, routinely we file for one spouse. I always have give a little disclaimer and provide information and let the client make the decision. There is some risk. My experience is the risk is pretty minimal if for the non-filing spouse. So I can appreciate those reasons. The non-filing spouse may not want to, expose their credit to it. Totally get that. So that it is possible. So that's something that I recommend you talk to your bankruptcy attorney about. If you're married and you're like, should we both file or should just one of us file? Definitely something to think about, something to consider. All right. Let's see here. We have a couple questions already. Let's jump into these. Bill says, I have 2 Capital One credit cards, 1 year past due, about $8,100, $5,200. Received a letter from Lloyd & McDaniel for payment. If they sue, will they have 2 cases and 2 different garnishments or one combined? Any advice? Well, I can tell you it could go either way. If the same law firm has both accounts, which it sounds like they do, they could file one lawsuit and just have 2 different claims or counts. So usually you get the complaint, it has like a facts section, then it has a different counts or claims. And so they could have 2 claims and say, hey, one Capital One card is $8,200, one's $5,200. So we think they're $13,000 some change plus attorney's fees and costs. They could also file it as 2 separate ones. Now, if they're on top of things, they'll probably just do it in one because they don't want to have to pay for 2 process servers, 2 filing fees, all that kind of stuff. But they could bring them both. Now, if they did file 2 separate lawsuits and they got 2 different judgments and they're trying to garnish your wages, in most states, there's a cap on how much they can garnish. So, for example, here in Arizona, the most they can take is 10% of your income after all your deductions are paid. So it isn't a situation if you have 2 judgments that they can each take 10. It's that the total that can be paid is 10. And so often what it is, the first creditor that files the writ of garnishment, they get 10% until they're paid, and then the next one just waits in line and takes it kind of that way. So that's how that's typically how it happens. So all right, let's see. Sorry, I'm just going through these questions real quick. Okay, this one says, do I recommend a lawyer for settlement or a company that can fix the credit? I'll put a link in the, if you're in Arizona, or I think they actually have an office in Minnesota, but I'll shoot you a link. These guys do a pretty good job. You can check out their website, and they may be able to help you out. Your other question, if you have a 1099-C, can debt collection sue and do garnishment? So the 1099-C, what that is, just understanding, so that you're not getting a regular W-2 employee, paycheck. You're like an independent contractor or something like that, or you're just getting a 1099-C. It is possible to garnish, but it's much more difficult. Basically, they can garnish anybody who owes you money for any reason. They could even do, let's say that you had borrowed a friend money and the friend's been paying you back each month. If a creditor found out about that, they could get a writ of garnishment where your friend had to pay them instead of paying you. As crazy as that is. So is it possible? Yes. When it's non-traditional, if you're self-employed, 1099, independent contractor, it makes it a little bit difficult. That is a reason why I see a lot of people will set up who are independent contractors. They'll actually set up an LLC themselves, and they will have their employer or the company that they're doing the contract work for, they'll pay the LLC, and then the LLC pays the person. That way, those funds could not be intercepted unless they had a judgment against the LLC. But so they're paying the LLC, and then the LLC makes a distribution to the other person. So, all right, let's see here. Randy says, how did one of the companies get a judgment against me if I was never sued by them? So, I think there was another, let me go back. There was another part to this. What do you suggest for someone in my shoes? I had 4 credit cards, all with separate debts. The debt together adds up to about $9,000. I have 2 judgments against me. I'm currently unemployed. And then you've said, how did one of the companies get a judgment against me if I was never sued by them? So the only way and you also added in there that you're currently not working. So it's obviously you can't pay them back if there's no money. And, without employment or without a regular flow of income, they're not going to be able to garnish anything or take money out of your bank account if there's nothing there. And so the question is, what can you do with these various judgments? And, the way that they got a judgment, you're saying without serving you, often they got permission to serve you through the mail, sometimes posting it. In Arizona, they used to allow them to post it in the classified section of the newspaper. And so that's how they end up with the default. So they actually did sue you to get the judgment, but you just may not have been aware of it. And it may be possible to unwind the whole thing. That's kind of a whole nother story for another day, but it may be possible. If you're not working, and as far as the ability to repay, some people will look at a bankruptcy option. Chapter 7 bankruptcy will eliminate the credit card debt, eliminate the judgments, credit cards, medical bills, personal loans, all those things go away in a Chapter 7 bankruptcy. And the fact that you're currently not working means that you'll likely qualify based on the means test. So that may be an option to look into a bankruptcy option. You may also be somewhat judgment proof right now, depending on what assets you have. If they can't garnish wages, if they can't garnish your bank accounts, if your house is protected under the homestead exemption, all of that may be so to the point where they can't really do anything, at least not right now, unless your situation changes. All right, let's see what Hercules has to say. I had a motion to dismiss hearing with LVNV. It was denied. Now in the 30-day discovery period, the plaintiff submitted a bill of sale, account transfer agreement, and a redacted spreadsheet with account details. The judge seems to favor the defendant. The plaintiff filed a motion for summary judgment, and the judge allowed it, even though we are still in discovery. I've requested production of the forward flow agreement. What additional strategy should I use to challenge the plaintiff's documents and win the case? Okay. And then you go on to say here, the plaintiff asked for a motion for summary judgment during the motion to dismiss hearing, and the judge said yes. So I guess what you need to clarify, has summary judgment been granted, or they just said yes to allowing them to file their motion? They shouldn't grant summary judgment just for asking. It's got to be something that's actually filed. So, as far as what you can do when you're talking about the information that they provided, the bill of sale, the account transfer agreement, the redacted spreadsheet with account details. If you're dealing with this is LBNV, this is a junk debt buyer. They didn't loan you money. You didn't agree to pay them any money. So they've got to prove that you had the underlying account. They've got to prove the damages, the amount owed, that you breached the contract, and they've got to show that your specific account was transferred between the two companies. If they can't do that, then they shouldn't get a judgment. And so what you need to do is go through each of the individual documents and look for inconsistencies, look for often like with the bill of sale, the account transfer agreement, you're often going to look at it. It doesn't have account level information, or it's all redacted. It doesn't have your name. It doesn't have your account number. It just says that these two companies transferred various accounts between the parties. So those are the kinds of things that you need to look for. There's evidentiary objections that you can raise. It's probably again, it's a little difficult to do at a YouTube type setting, but there are, most of these documents are hearsay. The monthly statements from the original creditor, those are hearsay. You can object to those being introduced. And maybe even, the spreadsheet, they have to be able to do what's called lay foundation for it. They have to have a witness come in and testify where it came from, who created it, where did the spreadsheet come from? Because the bill of sale and the transfer agreement does not typically reference a spreadsheet. It'll represent, an exhibit or a file or something like that. Another thing you can look at is you mentioned that you had that you want to get the forward flow agreement, which is I got the wrong thing here. Let's see here. Okay, so the forward flow agreement that you're requesting, what you can do if they file a motion for summary judgment. Summary judgment is filed under Rule 56 of most state rules of civil procedure. There's a subsection, sometimes it's D, sometimes it's F, 56D, 56F, or whatever it is in your state, that allows you to file a response to their motion for summary judgment saying, hey, judge, I need more time to conduct discovery before I can fully respond to their motion. Basically, they're saying, hey, judge, just tell us that we win. We don't need trial. Here's all our evidence. And you're filing a motion, a response, and you need to file it pretty quickly. Don't wait until the full time has gone by for you to file your response. File it quickly and say, hey, Judge, we need to pump the brakes here. They filed this thing. We're just barely starting the discovery period. There's things that I need to do and get before I can respond to it. What the court will generally do is they'll say, okay, you have 60 days to do your discovery, and then you have to file your response after that. So that may be the approach that you would take when you're trying to deal with that. All right. This is a question I got from the comment section over on the channel. It said, I would imagine the size of the purported debt may strongly influence how much effort these recovery companies expend in going after the debt. That is true, but what's interesting is it usually works different than what you may think. I've talked to attorneys for collection law firms about this because particularly here in Arizona, so our justice courts handle anything under $10,000. I see way more lawsuits for debts that are under 10 grand than I do debts for, say, over 50 grand. And you might think that that's backwards. Like, okay, if you have a credit card, you owe $75,000 on it and you owe it to Chase Bank, are they more likely to sue you on that one or the one that's $2,500? And in a lot of cases, you'll see they'll file the lawsuit on the $2,500 one before the $75,000 one. Here's why. Is because they know most people that get hit with the $75,000 lawsuit, you know what? They say, all right, I'm done. I'll file a bankruptcy. We're out of here. And they know that even if they get a judgment, it's unlikely that they're going to collect on it. Whereas a $2,500 lawsuit, they know that most people are not going to file bankruptcy over a $2,500 lawsuit. They're either going to pay it or they're going to be able to pay it in payments or do something to get it caught up. So we see a lot more low dollar lawsuits. I think the lowest one I've ever seen, and it was by a debt buyer, I think it was by Midland, $500. They filed a lawsuit for $500, which is nuts to me because the filing fee is like $180. They probably had to pay another $150 to get it served. But the thing is, the reason why they would do that is because they get interest. They can get interest on those judgments. And so if you don't get it squared away, they can have this $500 judgments. 10 years from now, the thing is like $4,500 or more that they're able to try to collect on. So, all right, let's see here. Joe says, due to being hurt at my job, I'll be having to file Chapter 7. I'll have some money to pay off smaller credit cards, but should I just pay the minimum? Here's what I tell people that call into my office. If you're in Arizona and I'm doing a consultation with you, I will say to people, once we know that you qualify for a Chapter 7, I will say, once you make the decision that in your mind, 100%, you are filing that Chapter 7 case, I would not pay any more money to credit cards. It's wasted money. It doesn't help the credit. It doesn't help your overall standing with things. You're going to get a few phone calls, but don't waste any more money on the credit cards, personal loans, all that kind of stuff. It's something that's going to be completely discharged in your Chapter 7 bankruptcy. It's better to then focus your things on secured debts, things with property or collateral attached to them, home loans, car loans, utilities, groceries, the four walls, we call it, the basic living expenses. Focus on those. Focus on things like child support, alimony, tax debt, things that don't go away, student loan debt. But the credit cards, I wouldn't even pay the minimum payments. Once you make that decision that you're going to file for bankruptcy and that you know that you qualify, that's where the consultation with an attorney like myself, again, I'm here in Arizona. I do a free consult with bankruptcies just to see kind of where you're at. And then once you make that decision, I would not continue to pay on those. All right. This question said, if you surrender your car to the lender, will that go into the Chapter 7 bankruptcy as well? The answer to this is yes. So I have clients, particularly right now. So right around, COVID 2020 to like 2022, if you bought a car, you know that you paid a premium. They added a premium on top of it. The interest rates are higher. And you're asking, John, how do you know this? I'll tell you how I know this because I bought a car in 2022. We needed a car. Our transmission went out. I got one and we walked in the dealership. But I remember they said to me, the salesman literally said to my wife and I, before we go look at cars, just so you know, there's like a $5,000 premium on all cars. Every dealer's charging it. It's not great. Whether you like it, don't like it. Sorry, you're going to pay $5 extra over MSRP on these vehicles. And on top of that, the interest rates, even with good credit, were not great. And they're still not great. We're still seeing some high interest rates on these vehicle loans. So we're seeing a lot of people now that are coming to us to do Chapter 7 and they're saying, I can't afford this vehicle anymore. We're seeing so many payments now that are over $1,000 a month, even on vehicles that aren't that expensive. And so people are like, what do I do with the vehicle? You can surrender the vehicle through the bankruptcy and you won't owe anything on it. And not only that, typically the timing of it, as soon as you file the case, they put an order in place that stops all collections against you. And so they can't actually come and even pick up the car. Even if you're like saying, hey, just come take it. Usually they want to get an order from the judge that asks them, hey, is it something where we can come take this? And then they'll let them. But that process usually takes a couple of months. So you might even still be able to use the car as long as you keep it fully insured during that time before you have to surrender it. Some lenders will even have you wait until the very end. So if you're in it really upside down in a car, or if you can't make the payment anymore, you're worried about that, you can let the car go back to the lender, even if that happens pre-bankruptcy, and then you're not going to owe anything further. I'm going to put something in the comments here. So there's a great company called Ascend Finance, and they have this free Chapter 7 bankruptcy calculator. You click on it and it just will walk you through the means test. Because that's the biggest thing that most people worry about is, am I going to qualify for the Chapter 7 or am I going to be stuck in a Chapter 13 for the next 5 years? This is just a free online calculator that can kind of walk you through some of the questions. It's more complicated than you'd think. The means test is pretty complicated in determining who qualifies and who doesn't, particularly if your income is above the means of the median income for your particular state. So go ahead and check that out. Let's see. We can do one more question, I think. Bill said, in negotiating a settlement with a charged off credit card account and arrive at settlement amount, can the credit card company waive late fees and interest to reduce the 1099-C to help with tax? So the 1099, often they'll issue you a 1099-C for any amounts over $600 that are forgiven when you're doing debt settlement. Settlement is totally negotiated. So sometimes you'll see that. It can also be, there's language that can be put into the settlement agreement stating that, it's not really a settlement. It's just that it's disputed on both sides. There are ways around it. If you're going to get a big 1099-C, it's for sure something you want to take to an accountant or a CPA when you're doing your taxes so that they can help you to reduce that liability overall. So, this is something that can be negotiated. But again, it's anything over $600 that's forgiven by the creditor. And it's different than if you file for bankruptcy. If you're in bankruptcy and the debts are discharged, the law makes a distinction between debts that are legally discharged and those that are forgiven by the creditor. All right. I think that'll do it for today. But hey, thank you all for checking in. Go check out some of those links that I put in there with Solo Suit, Ascend Finance. They can help you to understand kind of what's going on. Debt settlement, answering debt collection lawsuits. Go ahead and check those out. And with that being said, we